Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. I think in the classes I told you the Pulukuri Kotayya case, which is very famous case on 2 points regarding section 162 crpc and also as far as section 27 of the Indian Evidence Act is concerned. But even I am not sure whether I told you or not. I may have told you to the previous batches. Therefore, Mr. Pradeep Raju of Hinkollu, so he has sent a copy of the judgment. Actually, a synopsis we obtained, but of course, after reading the same, I could recollect that I have told previous batches. I am 100% sure. I don't know whether I have told you or not. But anyway, very landmark judgment. Pulukuri Kotayya versus King Emperor, 1946. The judgment delivered on 19th December 1946. Please remember, this is an appeal against the Bombay High Court, 1946. Anyway, very good judgment regarding two aspects, 162 and section 22(7) of the Indian Evidence Act. Right, as usual, let us have a cursory glance towards the facts of the case. So, just like any common part in India or our Rayalaseema area, the offence took place on 29/12/1944 at about 6:30 p.m. and it continued on the next day, that is on 30/12/1944 at 7 a.m. also, right, wherein the accused, of course, Pulukuru Kotayya is only the avatar. The other accused, some of their names is Sivaya, likewise Sevaya, Samaya. At the time the names used to be like that. The accused laid in wait for the deceased and others. Actually, they attacked them with spears and other deadly weapons to cause death. Right? It is a factious murder, simply to say. Right? As usual, the list of the accused was given to the police. The police officers came. In the first instance, the SI police came to the spot and he has registered the case and he examined 6 witnesses during the time of inquest. Please remember, he examined the witnesses during the time of inquest and sent the body for a PM examination. On the same day, the CI of police took up investigation. He examined the same witnesses, recorded their statements under 161 crpc and submitted them to the court along with the charge sheet. And during the trial, the main problem came. Actually, the defense advocate requested the Honorable Sessions Court that he was not supplied with the statements of the so-called witnesses recorded by the Sub-Inspector of Police. Of course, the statements recorded by the CI of the same witnesses was supplied to the accused defense party, but the statements of the SI, they were not found place. Of course, the SI was transferred to a different place. It has taken some time. In the meanwhile, the witnesses were being examined. Right? It came to light that the SI did not record their statements in the pro forma, but he has noted down the gist of their statements in his notebook. Yes, he can do. Please refer to section 160, 161 crpc. Yes, if time permits, he can he can note down all these things. If time constraint is there, yes, he need not. Simply, he can jot down the important points and later he can write the statements, because we all know that the statements need not be signed by the party. Right. So this is the case. Ultimately, he has to produce the notebook. So while giving evidence, at the time of his giving evidence, actually the case is posted for the next day, and on the next day he produced the notebook. And the copies, stencil or Xerox, we cannot call them as Xerox copies. Copies were made and supplied to the defense party. Of course, defense found some variations or contradictions. You may be knowing section 161 crpc, what for they are valuable only for contradictions, that's all, or omissions. For contradictions and omissions, for that purpose. Otherwise, they are not at all useful because they are not signed statements. Right? So anyway, since this rough notes was supplied to the defense party, basing on that, they tried to cross-examine. But of course, because the evidence, there are only minor contradictions and which are not of vital nature. Therefore, these are not much evidentiary value. The court declined the same. Finish. Oh, that means they have supplied the 161 copies and at the same time they are not of that much value. But please remember, here failure to supply to the defense party a copy of the 162 statements, yes, definitely it is agreed and court has pointed out the same, right? Whatever it is here, the important point is, please remember, the police officers, they can write the gist in their notebook and if they produce the same before the court, it is equal to the recording of 161 statements. తెలుగులో కూడా చెప్తాను. సహజంగా 161 స్టేట్మెంట్ అనగానే మనమంతా కేస్ డైరీ పార్ట్ 2 దాంట్లో రాసిన వ్యవహారం అంతా అనుకుంటాం. అది కరెక్ట్. కానీ కొన్ని సందర్భాల్లో పోలీస్ అధికారులకి టైం లేకపోతే సిడి ఫైల్లో జిస్ట్ రాసుకొని అక్కడికి ఇంటికి వెళ్ళిన తర్వాత లేకపోతే స్టేషన్కి వెళ్ళిన తర్వాత దాని యొక్క సినాప్సిస్ మొత్తం నీట్గా రాయవచ్చును. ఈ యొక్క ఎక్కడైతే మనం రఫ్ రాసుకున్నాడో ఆ కాగితాలని వాటిని కోర్టులో ప్రొడ్యూస్ చేస్తే సరిపోతుంది. దిస్ ఈజ్ వాట్ వాజ్ డన్ ఇన్ దిస్ కేస్. 161 ప్రకారం అయిపోయింది. యాజ్ రిగార్డ్ సెక్షన్ 21, ఈ 21 ఎవిడెన్స్ యాక్ట్లో ప్లీజ్ రిమెంబర్, సో యాక్చువల్లీ ఇక్కడే చెప్పేస్తాను. ద డిఫెన్స్ ఆర్గ్యూడ్ దట్ non-supply of the 161 statements definitely it is a breach of the so-called or direct infringement of section 162 crpc. Therefore, whatever advantage is there, the advantage is to be given to the accused person. That means they wanted to get the case acquitted. Of course, the matter has come to the Privy Council, Bombay High Court, against the judgment. Actually, the sessions later will come. So now part of 162 is over. Now coming to the second point, that is section 27 of the Indian Evidence Act. Please remember, this is actually providing an exception to the statements given before the police. Normally, according right from section 25 to 26, 24, 25, 26, we know that any confession given before police officer while in the custody of the police officer is totally inadmissible. But according to section 27, if any fact is discovered, then it is admissible. Only that part, not the confession part. Suppose in this case what happened is one of the accused stated that Ainala Saidaya, the name of the accused is Ainala Saidaya. He confessed that he and others at the abatement of our great man Pulukuru Kotayya laid in wait and attacked the deceased person. I stabbed the deceased with a spear. I hid it in the yard in my village. I will show you the place. Right? So if this is confession, then he has led the police party to the yard where it was recovered. So which is irrelevant, whether the confession, whether the particular object, what is this? Yes, in this case it is clearly established, but discovery to a physical fact, that means discovery of the so-called spear is relevant, but not the material fact. What is the material fact here? That they killed him, all these things, they are not at all relevant. Only recovery of the physical fact, that so-called MO, is relevant. So this is a very landmark judgment on the recovery aspect also. Please remember. So anyway, in this case, what happened is the lower court, they were satisfied with the judgment, the evidence of the witnesses, they have convicted. Bombay High Court also, yes, convicted, and therefore the matter came to the Supreme Court. Supreme Court was once again remanded or retransmitted the same to the High Court, stating that the fact of recovery is only regarding the recovery of the spear, but not other points. So the High Court has relied on other points also, because some of the witnesses turned hostile. Whatever it is, since the material fact recovery is only admissible, the court is directed, Honorable High Court of Madras, the case is retransmitted to High Court of Madras, so to consider or to take into account the recovery aspect, which may lead to journey of a physical object and not a material fact. So please remember, This point is 100% important. Very famous case, Pulukuru Kotayya. Please read the judgment and enrich your legal knowledge. Thank you very much.